defect. So in case if it's a manufacturing defect, in that case, I need to go and send a legal notice to the company. Okay, that is one. Second, I go to a hotel and I'm not happy with their services. The food was something that caused food poisoning. It's a very premium hotel that I have gone to, wherein I have actually paid for the services. So in that particular case, I can send a legal notice for deficiency of services. Then your divorce cases, then breach of contract under the Indian Contract Act. That is, two parties enter into a legal contract and they are not, one of the parties is manufacturing a pen and the other party, let's say party B, was supposed to provide them with raw materials to manufacture the pen. Party A has already made all the payments, but still party B has not provided the materials, or party B has provided substandard materials. In that case, also, I can send a notice for breach of trust. Then, what I can do is I can send a legal notice against my society if they are taking maintenance charges and they are not giving me certain facilities which they are supposed to do. I can send a legal notice to the builder when he doesn't give his deliverables on time. So there are various other instances wherein you can send your legal notices. Okay, so we'll just proceed further. I hope that answer was satisfactory. What should be the pointers that need to be included? Don't worry, I have got a complete draft of a legal notice for eviction, but before that, let's just do it. This is a reply. Okay. Huh. I've just missed out a slide. One slide is missing. The first slide is missing. So first is obviously all the case that you need to mention. Second is the legal provisions or statutory requirements. Just give me 1 minute. Huh? So what happens is basic pointers that anybody would include in a legal notice is um, second thing is establish your local standard. That is, how does your client have the permission to send a legal notice in this particular case? That is, as I just mentioned, in case of breach of contract, just because party A and party B have entered into an agreement, and that agreement is what gives rights to my client to send a legal notice. Okay. So their legal relationship needs to be established. Second thing, I will mention the same agreement as an annexure. Now, any legal battle cannot be fought without documents. Your documents are your biggest weapons. That is something that you need to remember. Okay, so I will be attaching this document. Third thing, I will be attaching the series of disputes. Now, I am saying that, this front person did not give me payment and I have been asking for money. I have been supplying the materials, but he has not provided me with anything. So he has not provided me with anything, and my documents have not come back to me. My raw material, not documents, sorry, my raw material has not come back to me. In that particular case, Just give me 1 minute.
हेलो। हेलो मैम। हेलो ऐश्वर्या मैम।
Hello, I'm here. I'm here. Just give me 1 minute. I've
ओके
just
ओके। आई थिंक मुझे लगा आपका नेटवर्क कनेक्शन कट।
नहीं, मेरा नेटवर्क में प्रॉब्लम है ही. ओके, या there is some issue with the opening of the file, so I'll just continue the session file. I'll just share it in the group in some time. So yeah, when you talk about a legal notice, there are
अगर आप
certain
मुझे अगर आप मुझे शेयर कर दे, मैं प्रेजेंट कर सकता हूँ, कोई प्रॉब्लम नहीं है ऐसे।
yeah, I'll just do it. As of now, I'll just continue with this slide.
ओके
Okay.
ओके ओके।
Other one, I'll share it soon. Okay, ये जो share है, that is getting hung from, I don't know, from the beginning of the session. So let's just continue with it. So you will have your basic facts, you will have your reference of documents. It will also mention on why you are sending a legal notice. For example, I said that as per clause 10 of your contract dated so and so date, it was mentioned that on every 10th of the month you will make the advance payment for the receipt of the materials, and the other side will send you the complete details. Okay, will send you the raw materials by 15th of every month. Now since last 2 months you have been sending raw materials, you have been sending the advance money, but the defendant has not responded, or he has been sending low quality materials, or whatever are your grievances, you will mention in that. Okay, so this is how you will send a legal notice saying that I want to terminate this agreement, I want to go ahead with this agreement. If I want to go ahead, I will say specific performance. That is, he needs to send all the raw materials by so and so date with the quality of materials that we have agreed. Not sending me substandard materials or sending me the wrong materials. Okay, and then will come that I wish to terminate, or whatever is your brief that you are looking for. Now, let's talk about a reply to the legal notice, how it should be crafted. Now, sending a reply is also an art. Okay, first of all, as I said, if you do not have sufficient time to send a detailed reply, always send a short reply. Because certain times, what happens is you may not have the time. Your client will take certain time to get all the documents. If your client is making a claim that कि नहीं मैंने तो उसको पेमेंट कर दिया था, he is the one who's making all wrong allegations. If you are making claim that you have made the payments to the front person, then you need to support the same with your bank statements or your receipts. Okay, and sometimes it takes time to find these documents, it takes time to uh, uh, create your case. So in that particular case, you have to first send a preliminary reply and then a detailed reply. But when you're sending a reply, your first step will always be acknowledgement of the notice. That is, you have to acknowledge that I have received the legal notice and on so and so date, and I have replied within the 7 days duration of whatever you have given me. Now, reference to the notice. Whatever your answers are, first it has to have the reference. In a reply, you can never start by uh, accepting anything, and you can never start your reply by stating your own facts. You have to first deny everything that they are saying. So when I say reference to notice, it will begin as dear advocate so and so, I have received a notice dated so and so on via courier, RPAD, whatever, on so and so date. I wish this is notice dated so and so, reference number of the notice so and so, towards sent by you on behalf of your client, Mr. XYZ, for breach of contract or for whatever purpose. And the first para will be the description. Your second para will begin. On behalf of my client, I deny all the allegations that have been made by you in the said notice. At the outset, you have to deny all the statements that is mentioned. This is where your fancy English helps a lot. You can call the notice frivolous and this and that. This is where we had the maximum fun. You have to clearly deny each and every step, each and every sentence that is sent in a legal notice. If you don't deny anything explicitly, it means you have accepted whatever allegations they have made against you. Okay, so you have to deny the allegations made that my client has not been sending regular raw material is completely absurd and totally frivolous. My client states that the last consignment was sent to him by so and so date, and this is the challan the of your client's factory, which mentions that on so and so date he had received certain consignment. Okay, so you have to explain the complete facts of the case. After you deny everything, you have to start with your version of the story on what exactly happened. Okay, so as per your records, you can say that according to my client, uh, your client was supposed to send an advance of rupees 100, but instead of 100 rupees, he has been sending an advance of only 50 rupees, and that's why we have been sending half of the raw materials or whatever it is. Then comes your legal ground. That is with reference to agreement dated so and so, so and so. I want to state that this is nothing. Your action of breach of contract has been carried out by your client because you have not been making an advance payment. I have been always sending you the proper money. Then comes rebuttal. If there are specific claims that you want to address and you want to notice separately or systematically, you can give it there. Okay, then you can call for an amicable solution. You can say that, let's have a Zoom call or let us all sit together and discuss so that all this is settled. Now this is optional. Either you can give a chance for settlement, or you can say that no, you have been spreading all wrong rumors and defamation. I am also within my legal rights to initiate a legal procedure. These things are something that will differ from case to case. Okay, I cannot give you a standard template saying that ये case में ऐसे ही होना चाहिए. Everything differs from case to case. Then you can attach any supporting documents if required. Now, supporting documents in a legal notice should not be expedite. That is, you need to ensure that you attach only one or two legal supporting documents. Your legal notice should not be a thesis. Okay, you can give just a 2 page or a 3 page legal notice, that's sufficient. It should have your facts of the case and all the details. But generally, people think that the more pages I add, the more it is effective, but it's not always true. The shorter your legal notice, the more difficult it is to reply. Because what happens is when you give a long legal notice, okay, when you send a 5 page, 10 page legal notice, you are stating too many things. So when you state too many things, the other side already knows what your stand is going to be. So you need to strategize and ensure only limited information, but important information is provided. Then, as always, your uh, conclusion, that what exactly do you want. You can say that I have always been faithful, my client has always complied to whatever deliverables he was supposed to do, but there was always delay from your client, blah blah blah. Whatever you want to say, you can say. Okay, then is your date and your signature. That is the lawyer's name, lawyer's signature, and the stamp and the date. Now, some of the clients, we have something that is called as an office copy. So, whenever we send a legal notice to the other side, we always keep a copy in our office, a hard copy, not soft copy, which is signed by the client. What happens is a lot of times people then claim that I never said put this in the legal copy and legal notice. I never said to add that clause. This is how it had to be said. You didn't take my opinion. No. Always be transparent to your client. Always be honest with your clients. Okay. Give them an opportunity to give your inputs. These are all personal choices. Uh, Whether you want to follow or not is a different thing. But all the law firms, at least all the tier one law firms, follow this practice because you never know. Because we generally work for companies. So in companies, what happens is one particular person may be a legal manager today, but tomorrow it may be some other person. So we do need the records. Okay, you cannot go back tracing 10 legal managers for a company. So that is the practice, what is generally done. So any queries till now? Tomorrow we will do the actual drafting. Any queries, anything you want to ask, you want to say? I'll wait for a couple of minutes. You can type it out in the chat box.